7 days. 7 days have passed since I foolishly sought sanctuary in your courtroom as a victim of domestic violence, as a victim of emotional abuse, and as a victim of parental alienation. 7 days ago, I still had faith in your jurisprudence, in the mandate of your office, and in your discretion to favor what is in the best interest of the safety, health, and well-being of my 2 children, and so I petitioned your aid because the mother of my children is an abusive, manipulative bully without remorse, without empathy, and without boundaries. For 5 years I have advocated for my rights as a father in your courtroom, while she has played games with evading service, with not showing up for the appointed times of mediation, and with purposely missing hearings in order to avoid and delay the outcome that she knew would force her to grant visitation time for the children and I. For all of your time on the bench, I am truly bewildered by your apparent lack of awareness concerning the severity of psychological damage, due to the inherent deeply scarring emotional traumas, suffered by children who are at the mercy of an abusive parent pursuing an agenda of parental alienation, which are even more intensely experienced by special needs children and, in particular, those with autism spectrum disorder. Like my son, who was 7 when I had my first hearing in your courtroom with a domestic violence victims advocate at my side, who is now 12 years old and who will not need your opinion in another 5 years or so. I'm not sure how familiar you are with child development, but the damages of parental alienation syndrome incurred by a child from the ages of 7 to 12 can be practically irreversible, and even more so when that child has also been diagnosed with autism spectrum disorder. The visitation orders that I have had to fight their mother for in your courtroom have been hard-won, and she has tested the strength of the court's orders time and again because she has no respect for them and only complies with what she has learned will result in a visit from uniformed enforcement authorities equipped with badges and guns, and she disregards the rest. Her attitude is, "Make me." And so, the number of times that your orders have been violated by her are too numerous to calculate after this many years, because she assumes if there's no threat of law enforcement then your words do not need to be obeyed. So far, I have not provided you with any new information about the case, and, indeed, I will not. You stand accused of an abuse of discretion because you awarded the abusive party on Friday the 13th, 7 days ago, when you made the decision to be an accomplice to her abusive agenda of parental alienation, to legitimize, increase, and prolong her abuses of the children and myself, because it was in alignment with your own covered agenda concerning your beloved publicly administered institutions of traditional education, which is the interest that you were in fact protecting and not, as you dishonestly said, those of my children. In truth, Commissioner Shelly Seymour of Department 7, the Family Law Division, Merced County Superior Court of California, you outright refused to hear any testimony from me that would advocate for what is actually in the best interest of my little ones, as the one person on earth who cares about them as human beings. You additionally denied me the opportunity to present my case in further mediation, and, without justification, prohibited me from filing any future request for order in this court unless and until I personally hire a third party to perform a full-scale evaluation on my behalf, which you warned me will be very expensive. You then proceeded with what is in the best interest of your covered agenda and stripped my children of their right to have their social and educational needs met outside of your beloved publicly administered institutions of traditional education, because you had an ally in the form of the domestic violence abuser, the hostile respondent, the restrained party, the parental alienator, their mom, and you believed that that was the only excuse you needed. But, you are out of touch with the current reality. 7 days ago, you took advantage of the trust one had placed in you to protect the rights of my children, to provide the authoritative power necessary to ensure their safety, health, happiness, and well-being in the face of their mother's abusive juggernaut agenda of parental alienation, and to allow these children to finally have equal time with each parent, without any increase to their time spent in transportation, now that they had been enrolled in our private home school and were no longer shackled by the confines of the oppressive schedule employed by publicly administered institutions of traditional education. And you did not You instead used your discretionary power to strip the children of their educational rights and to strip me of my parental rights by granting the wishes of their abusive mother, the restrained, hostile respondent who continues to thumb her nose at you because you are out of touch with the current reality. You told yourself that the publicly administered institutions of traditional education are always in the best interest of the children, even at the cost of making yourself an accomplice to parental alienation abuse, and so you employed the discretion of your office without the need to provide any further justification and without allowing any opposing argument before quickly tapping your little wooden hammer and cutting the line to my court call. But, you are wrong. You are dead wrong. If you had allowed me to speak, I would have told you that the reason it was necessary for me to register a private home school with the state of California in order to ensure that the social and educational needs of my children could continue to be met was due to the overwhelming failure of the institutions of traditional education in response to the COVID-19 global pandemic, in which the children had been previously enrolled. So, I can only conclude that you have some outdated idea of what you think exists in relation to traditional education which cannot in practice actually exist in our current reality, where everything traditional has been broken apart by the very real and rational fear of death, and you will not accept any truth that threatens your notion that has you convinced these institutions, which are struggling the most with the pandemic and no longer adhere to the traditional delivery of education, are always in the best interest of a child. It is for this reason alone that you have demanded the lives of my children to be put in untold risk of death in the form of close contact and exposure with the publicly administered institutions of traditional education, student body demographic and forced socialization. In a world where people are too afraid to breathe without a face covering because of the fear of death, or to stand in public without a 6-foot radius between them and another human being because of the fear of death, where people are willing to take an experimental and untested vaccine, even though it has no characteristics of a traditional vaccine which contains antibodies and does not modify your RNA, because of the fear of death, where it was recently announced by the CDC that these same vaccines are ineffective, and so there is a greater fear of death gripping the world than there was when the public school administrators made the decision to reopen their institutions of traditional education to the masses of children. Do you actually believe your cavalier abuse of discretion to threaten the lives of my little ones for the sake of their best interest can be rationalized? That is absolute madness. 5 days out of 7 now my children have been forced into an unnecessary peril for their very lives, due entirely to your unforgivable abuse of discretion, and I challenge you personally, Commissioner Shelly Seymour of Department 7, the Family Law Division, Merced County Superior Court of California, to spend the next 5 days out of 7 in close contact with a classroom full of public school elementary children at one of your beloved publicly administered institutions of traditional education, and you can let me know how you feel about your chances of contracting this virus and dying like so many other people around the world already have. It's not like cancer, where people can get treatment and live with it for years. In my own experience, I've lost a lifetime friend to this virus, and it happened in a matter of weeks. 1 week has already passed since you abused the discretion of your office and demanded that I allow you to unnecessarily force my children to be placed in these death camps because their demented and abusive mother wanted it, and that was all the justification that you needed. It will be 3 more weeks until the visitation orders that you denied me the opportunity to change allow me to spend 1 day and 2 half-days with my little ones. Do you understand that your actions, which you committed at your officious discretion, have created the very real concern that I may not ever see them healthy and alive again? Think about it before you dismiss the horror of what you have done. Rather, what you have done shall be dismissed. In the name of holy truth, divine love, and universal honor, so be it.